with what we're going to cover today. So first, we're going to cover coverage. So is your organization covered by the FLSA? As a general rule, many organizations, nonprofit organizations, are not covered as an entity by the FLSA, and we're going to get into that more. However, many employees will be covered. So after we get to that, assuming that you and your employees, or some of them, are covered by the Fair Labor Standards Act, we're going to talk about exemptions from the Fair Labor Standards Act. So these are the exemptions that you've probably heard about in the past. So oftentimes, and this is a kind of a misnomer, people are going to talk about employees being salaried, so they're not covered by overtime or minimum wage provisions. That's something that we're going to get into. That's not the case. The exemptions that we're going to talk about today are the white-collar exemptions. They're the most commonly used exemptions from the FLSA. There are other ones that we can talk about too, but we're going to stick with the white-collar exemptions, at least in my presentation. Then we're going to talk about pay for non-exempt employees and options that you have for employees who are covered by the FLSA's requirements. And again, I'm not sure if this was caught when I was talking about it, but and we'll get into it, but the 4 requirements of the FLSA are, number 1, payment of a minimum wage to employees who are covered by the FLSA. The federal minimum wage is $7.25 an hour. Second requirement is overtime payments for hours worked over 40 in a work week. Third requirement is record-keeping requirement, so you have to keep track of the time that non-exempt employees work. And the fourth requirement are prohibitions on some types of child labor. And again, this is a law that was passed in 1938 initially, so the child labor laws are a little bit less utilized or analyzed today. It's a bit of a relic of the 30s when kids were working on farms or in factories. So the next thing that we're going to talk about are volunteers and how you and your organization deal with volunteers. We're going to touch on that just because I know a lot of nonprofit organizations do utilize volunteer work, and it's an important part, usually a crucial part of nonprofit organizations' labor. Then we're going to touch on a couple issues related to bring your own device policies and what employees are doing when they're using their cell phone to check email or to do work. This is over the past 5 or 10 years has been a increasingly important part of wage hour law, and it's something that I'm sure your organizations are dealing with, whether you have a policy or not. Employees are connected today, and we need to make sure that we're handling that connectivity properly with wage and hour laws. Then we're going to talk a little bit about noncompliance, and this is the stuff that scares organizations and individuals into compliance with the FLSA. What are the consequences for not complying? So let's start with, we talked about the 4 FLSA requirements, and just kind of so that we're all on the same page, when we talk about non-exempt employees, we're talking about people who are not exempt from the FLSA. That is, they are covered by the requirements of the FLSA. If an employee is exempt, that means that that your organization does not need to comply with certain of the requirements of the FLSA for certain employees. So let's jump into the exemptions. Again, the default rule that you should be operating under is that all of the people that work for you are non-exempt. That is, they are covered by the FLSA. There's a bullet here about the new rules affecting white-collar exemptions. We're going to get into the white-collar exemptions. You may have heard in 2016, under the Obama administration, there were proposals to change some things about the white-collar exemptions. Those rules have been put on hold. There's an order from a judge that has stayed implementation of those rules. So those rules haven't gone into effect, but it is a good reminder that there is potential movement in this area, so this is a thing to keep your eye on, whether or not those regulations are updated eventually. First, let's talk about coverage. Does the FLSA apply to you, your organization, and your employees? There are two types of coverage under the FLSA. First, and I don't think there's a slide in here, so forgive me for that, but the first point of coverage is what they call enterprise coverage. Enterprise coverage means that the entire organization is covered by the requirements of the FLSA. Enterprise coverage is accomplished by an organization that engages in some sort of otherwise competitive business or commerce, and that business takes in at least $500,000 in revenue. You might be thinking right now, hooray, we're not covered by the FLSA. We don't bring in $500,000 in revenue. That may have been the case up until the 1960s, but in the 1960s, this law was updated to include individual coverage. Individual coverage means that individuals in your organization, even if you do not take in the equivalent of $500,000 or more in revenue, individuals will be covered by the FLSA if they engage in interstate commerce as a regular or typical part of their duties. Now, interstate commerce is a broad category. So if you're using the phone to talk with people outside of the state, if you are using the internet to order supplies, you are engaged in interstate commerce. So for all intents and purposes, most employees are going to be covered individually by the FLSA for nonprofit organizations, even if you don't meet that $500,000 enterprise coverage. So we're going to be assuming here that most of your employees are covered by the FLSA under this individual requirement. There are, some potential exceptions to that rule, but if you have questions about that, we can talk about that. But again, the default here is employees are covered, and getting into the exemptions, how do we decide whether or not we need to pay overtime or pay minimum wage? We're going to be thinking about exemptions from the FLSA. So oftentimes, employers tend to think, if I pay somebody a salary, we don't need to worry about overtime. That's a misconception. All of the exemptions that we're going to talk about, the white-collar exemptions, which are the professional exemption, the administrative exemption, and the executive exemption, those are kind of three-tiered exemptions. So the three requirements for each of those exemptions are, number one, they're paid on a salary basis. That salary basis has to be above $455 a week right now. Salary means that they are paid that amount or more every week, essentially regardless of whether or not they're working, and there are some exceptions to that that we can get into if you'd like. But salary basis means salary, right? So they're getting paid a salary, and it doesn't matter if they came into work for 5 hours one day, you still pay them whatever their daily salaried rate would have been. So that's number one. If you don't have salary, you can't be exempt under these exemptions. But there are also other requirements that have to do with the duties that each of these employees perform. So we're going to talk about these duties with respect to each of the three exemptions the two main exemptions that we're going to talk about. The first one is the executive exemption. So again, in order to be exempt from the FLSA, so the thing that most people worry about is, do we have to pay overtime to this employee? The first thing is they need to be salaried, like we talked about, at least $455 a week. The second thing is the duties test. And so the duties that an employee who you want to be exempt under the executive exemption must meet are, number one, their primary duty has to be managing the enterprise, so your organization, or a customarily recognized unit of your organization. In addition, this employee, an employee that you want to be exempt from with the executive exemption, must customarily and regularly direct the work of at least 2 full-time employees. Also, along with the directing work of employees, an employee who is exempt under the executive exemption has to be able to hire, fire, and discipline employees or provide significant recommendations on hiring, firing, and discipline. One of the examples of issues that we run into with the executive exemption, and I'm going to kind of throw out some hypotheticals here. Some of them are based on actual cases, but I'm going to try to highlight some of these issues that we face. So number one, with the executive exemption, is the primary duty. Primary duty is managing the enterprise or a customarily recognized unit. So, for instance, customarily recognized units might be the finance department or the HR department. If you have an assistant manager or a person who's second in charge, that probably doesn't meet the necessity of managing a customarily recognized unit. So really the executive exemption is geared towards people who are running the business, who are making decisions and managing employees in that business. Directing the work of 2 or more employees can get tricky. One of the things that we recommend generally is that you don't want to call somebody exempt when they only direct 2 employees. Technically, that might work, but the issue is that this person has to be spending their time directing 2 or more full-time employees. So they have to be spending their time directing the equivalent of 80 hours a week of employee time. So it can be, 4 employees doing 20 hours a week or more. Another issue here is that you can't share those responsibilities among a bunch of different people. So if you have somebody who is an employee who reports to 3 different people, and that employee is one of the 2 people that you're relying on for somebody's executive exemption, it's not going to work. You can divide up hours. So for instance, if a 40-hour employee reports to 4 people, each of those people could take, if this is the way it really works, 10 hours of responsibility. But things get complicated when you start dividing up time like that. So just because somebody generally supervises or contributes to supervising a couple people, you're going to have to dig into it a little bit more. And as I alluded to earlier, this is going to be a theme of all of these exemptions, and frankly all of the issues we're talking about today, is that it really depends on the circumstances involved here. Same thing with authority to hire, fire, discipline. You want, and we would have to dig into the specifics of a situation, but an employee who is considered exempt under the executive exemption is going to need to really have this authority. So, taking the opportunity to make suggestions to a higher up, maybe the executive director of your organization, that may or may not qualify as the authority to hire, fire, or discipline, or making substantial recommendations. So again, this is a tricky exemption. Just because somebody is thought of as a manager or somebody is thought of as integral to your organization doesn't mean that they're going to be an executive. One example that I use in the for-profit world is executive vice presidents. You may know that many companies have hundreds of executive vice presidents. Just because executive is in your title does not mean that you are covered under the executive exemption. Brings me to another point, and this is generally true of all of these exemptions. Job descriptions mean nothing. So job titles mean nothing, as I explained, but having a job description can be evidence of what ideally an employee is doing, but what really matters is what the employee is actually doing. There's a kind of scary example from a convenience store that had I think it was an assistant manager, but they were on duty, managing the store half of the time. They supervised them. They were supposed to supervise employees, and they were supposed to keep the books, do all the things that the general manager did when the general manager wasn't there. But this employee wasn't following the direction of the general manager. They weren't filling out the reports. They weren't doing any substantial management of other employees, even though they were supposed to be doing that, and they were being written up for not doing it because, in fact, they weren't meeting these duties. That assistant general manager was not exempt from the FLSA. Let's go to the administrative exemption. This is the most widely used and most widely misused exemption. Again, the kind of first thing that you want to make sure if you're going to consider somebody exempt under the administrative exemption is that they're getting paid a salary. That salary's got to be over $455 a week. But again, a salary is not enough. They have to meet a couple of duties. And so the first duty test that we talk about is that their primary duty, so their most important, or the general reason that they're working there, their primary duty has to be office or non-manual work that's directly related to management or general business operations of the organization. What does this mean? Think about when the FLSA was passed. This was in the 30s. We were thinking about a lot of new movement in manufacturing and production. What we talk about here is there's a production and management dichotomy. So the FLSA was meant to cover people on the production floor, people putting together the Fords and putting together manufactured goods. This exemption, the administrative exemption, is meant to cover, so to exempt from the FLSA, individuals who are working in the back office. They're not involved in the production of whatever the good is that your organization provides to the public. So typically, we're going to see individuals doing tax work, involved in HR, involved in finance, involved in sometimes operations and logistics. So the primary duty has to be non-manual labor. One example of how tricky this can get that I like to use is tax preparers. A tax preparer might be exempt under the administrative exemption with this primary duty being office or non-manual work if they, for instance, work at one of your organizations that doesn't provide tax services to the public. However, a tax preparer or a CPA probably would not be covered under the administrative exemption if they work, for instance, for H&R Block. Why is that? It's because the product or the service that H&R Block provides to the public is tax preparation. So in a sense, that tax preparer for H&R Block would be like the factory worker who is producing the products that are provided by the organization. So again, the circumstances matter. You can't just say because you do HR work or because you do finance work, you're automatically exempt under the administrative exemption. The second part, and this is the part that trips most people up or most organizations up, is that in addition to the primary duty test, in order to be exempt as an administrative employee, your work has to include the exercise of discretion and independent judgment as to matters of significance. This is tricky because so often we as managers think about our employees as doing significant work, of exercising independent judgment and discretion as to that significant work. But those words in a vacuum don't matter. What matters is what individuals are doing on the ground. So for instance, an employee who is doing high-level work, they might be figuring out how to care for clients at a home care system, or figuring out how to do logistics and bringing in equipment and complicated work. That probably is not exercising independent judgment and discretion if they're following procedures. So if you have a manual that says, we get our supplies from these 5 suppliers, and here are the prices that we're willing to pay for these supplies. One thing that you can think about is if you're thinking about this independent judgment and discretion prong, an employee is going to have to be able to be faced with a problem or a situation and come back to management with whatever solution that employee thinks might work. If they're relying, again, on procedures, manuals, policies, it's probably not going to qualify as independent discretion. There's all kinds of case law on this, and again, this is something that really depends on the duties that employees are performing. Another thing to note, and this is just adding more complication, and another reason to get in touch with the Pro Bono Partnership if you have questions, is that oftentimes employees might come into a position and you'll have this job description talking about all of this independent judgment and discretion and management that they're going to be doing, but sometimes at the beginning of their relationship, they're learning, they're training, they're not actually performing those duties. They may grow into that, but during the time that they're not performing the duties that exempt them from the FLSA, technically they're still covered by the FLSA. So, again, even if you're hiring a chief technology officer who generally we would think is exempt because they're managing people under the executive exemption and managing a customarily recognized unit, the IT department. If they spend their first month kind of training and figuring out the systems and not actually doing managing, for that month they're not exempt. And if you automatically consider them exempt and don't pay overtime and don't keep track of their time, you're liable or potentially liable for the back pay and other penalties that we'll talk about later on. So you have to be really diligent in thinking about the duties that individuals are actually performing. So that what I've been talking about hits on, I think, the one of the next slides is, are they really exempt? The other exemptions that you might want to think about, I'm not going to get too much into because they're a little bit less used, but also important in the partnership, and we can answer questions on them. There's a learned professional exemption. This, among other requirements, has to be a person who has engaged in a term of long-term study in order to perform the job that they're performing. Creative professionals, sometimes people like chefs or artists can qualify for the creative exemption. And then there's also a computer employee exemption and a highly compensated individual exemption. Again, less used exemptions can be important, and we're happy to answer questions about those if you have any.
Does this apply to part-time employees, like if they are hired to work, say, 30 hours a week,
Mm-hmm.
but then there's a week where they work 35 hours, not quite 40, but 5 hours more than they're normally required to work?
So if we're talking about exemptions, well, well, let's go back. Generally, yes, the FLSA does apply to part-time workers. Portions of the FLSA that don't necessarily apply to a part-time worker, so if somebody's working 20 hours a week, they're not working overtime. So the overtime provision only applies to an employee, and we're going to get into what some of these things mean, but overtime provisions only apply to an employee who works over 40 hours a week in a work week. So if somebody works 30 hours a week, they don't need an exemption to be exempt from the overtime provisions. They still do need to be paid the equivalent of the minimum wage if it is a covered employee. So yes, the FLSA definitely applies to part-time workers, and exemptions can apply to part-time workers as well. Again, they still need to be paid the minimum salary. Doesn't matter how many hours they work, in addition to performing the duties that we just talked about for the executive and administrative exemptions. So sure, you could have an employee who only works 20 or 30 hours a week who you consider exempt, as long as they're making the equivalent of the minimum salary basis and they're a salaried employee. Non-exempt employees. What do we do? One misconception, and this is a corollary to the misconception I think that people have about if somebody is salaried, we don't have to worry about overtime or minimum wage. That's not the case. It's also not the case that if somebody is covered, that they have to be paid on an hourly basis. And this is, if you have any questions about this, we've dealt a lot with employers who think that they don't want to go to considering employees non-exempt because that means you have to go to an hourly basis, and some employees say that they don't like having to track their time or punch the clock. To be clear, if an employee is covered by the FLSA, that is, they're not exempt under any of the exemptions we discussed, they still will need to keep track of their time. That said, there are other ways to pay employees than just straight hourly. And so we can get into that a little bit. In addition to hourly wages, you get paid $10 an hour for the hours you worked under 40 hours, and then over 40 hours, you would get paid 1.5 times your regular rate. In addition to that, you could also, or as a different option, you could pay people a salary. And you could pay people a salary even though they're not exempt. If you're paying somebody a salary, that just means you'll still have to pay overtime. And if they're not exempt, paying overtime for a salaried employee can be done in one of two ways. You can have an agreement with the employee that a salary is meant to cover 40 hours a week, and anything over that 40 hours will be paid at 1.5 times that employee's regular rate. I think we'll get into calculating overtime, so the regular rate is going to be really important, and we'll talk about that in a second. Another way that you can pay employees who are not exempt from the FLSA, employees who are covered, a salary is to say your salary is meant to cover all of the hours worked in a week. Again, under that scenario, for an employee who is covered by the FLSA, you are going to have to pay overtime. But because the agreement is that the salary, say $500, is going to cover all hours worked, you only have to pay 0.5 times their regular rate for time over 40 hours. We're going to get into that in a little bit, but I guess my point is, if employees are not exempt from the FLSA, if they're covered by the FLSA, you don't have to just pay them by the hour. So if you think in your organization that having a salary and telling employees that they have a salary is important, you can do that without, without kind of towing the black and white line of whether or not they're exempt. If an employee is non-exempt, we're going to move on to accurate timekeeping.
Corey,
Yes.
another question.
Sure. Yeah. Thank you.
If there's an employee that's specially trained legal advocate that's sworn in by a judge, and they meet the financial qualification, could they be categorized as exempt employees?
If an employee, so there are a couple potential exemptions there. If it's a legal advocate who has a law degree, then potentially yes, as an attorney. Generally, attorneys are not covered by the FLSA if they're working in their capacity as an attorney. And again, this can get complicated, so that's generally. If this individual is not an attorney, and what we would use is the learned professional exemption for attorneys. If a legal advocate sworn in by a court is not, has not gone through a prolonged course of study, you may, for instance, be able to get this through, a graduate degree in social work, or it doesn't just have to be an attorney. But if there is no kind of prolonged course of study that was necessary in order to perform that work, you're going to have to go back and look at the exemptions that we talked about. It sounds like that person is probably not an executive, probably not, customarily and regularly directing the work of 2 or more employees. They're not managing the business operations of an organization or of a customarily recognized unit of that organization. Administrative exemption, again, it's difficult to say. You're going to have to go through the duties test and then also try to figure out whether or not are they following procedures. Is there a court manual of how to handle these cases as an advocate? Generally, I would say you want to operate under the assumption that they are not exempt, that they are covered by the FLSA. Unless you can go through each of those steps in the administrative exemption or kind of dig more into the learned professional exemption. So timekeeping. This is an important part of the FLSA for employees who are covered by the FLSA. I litigate these cases, so I typically see a case like this when the Department of Labor or a plaintiff's attorney has come to us with either a complaint or a lawsuit saying my client, or for the DOL, the employees that we are coming to you on behalf of, they are not exempt employees and they're covered by the FLSA. But you have not been paying them overtime or the minimum wage. When I litigate these cases, it's really difficult to come up with defenses when we don't have any accurate timekeeping. So, that's not just, employees punch in that they work from 8 to 5 with a 1-hour lunch every day. In fact, I hate seeing that when I get a stack of documents from an employee who has clocked in 5 days a week from 8 to noon and then 1 to 5 every day. I'm not going to say it's worth nothing, but everybody knows that that's not how life works. You don't get into work at 8 a.m. every day, and you don't take lunch immediately at noon and come back at 1. So that's not to say, a lot of employers that we represent say, well, we have people write down their time on a piece of paper every day. That's fine. You don't have to have, expensive and complicated timekeeping systems. You don't have to have an actual, clock on the wall that you punch, and you don't have to have computer systems or things on people's phones. All of those things can be helpful, but the key is that you need to make it clear to your employees, and frankly usually to your managers who manage employee time, that they need to be keeping accurate records of their time. One of the things that I like to talk about, we've been going through all these requirements, and hopefully you're not too stressed out right now, but it can get stressful. Geez, are we doing this right? Are we paying folks the right way? Or are the people who we consider exempt, are they actually exempt? I think that thinking about this subject gives you, as somebody who's running an organization or managing individuals, the opportunity to think about how do we best treat our employees, and how do we manage the people who manage our employees. So, with respect to timekeeping, your job, if you're an executive director of your organization, is to either directly tell employees how important it is that they are accurately recording their time, or to manage the managers and make sure that your managers are seriously imparting this on their employees or on the people that they manage. And so I like to think of issues when they come up with wage and hours kind of teachable moments. And so, one thing to think about is when I'm talking, or when I'm advising employers about talking to employees, is that we want to pay you for the time that you work. Not only are we required to do so by the law, your time is valuable. And so when you're working, you need to keep track of that. And when you're not working, you need to keep track of that too. And we're going to get to bring your own device policies, but people doing work, quote unquote, off the clock or off premises, work is work. And so if you as an organization are permitting them to do work, or if they're doing work and you know about it, or you're letting them do it, it's still work. And so setting clear guidelines for your employees about when work should be performed. When I talk to employers about people doing work off premises, if you don't want that happening, I think a great way to talk to employees is that, look, work here during the day, or wherever your work site is, but when you go home, have fun with your family, have fun with your friends, do the things that you enjoy outside of work. Don't be doing work outside of the time that we have told you to. The other thing is, you can discipline people for not keeping accurate time records, or for doing work off premises if that's not what you've told them to be doing. But what you can't do is not pay for that work. So again, it's a teachable moment. It's a teachable moment for employees who are not currently accurately recording their time, and for managers who aren't asking their employees to do so. One of the things that we like to recommend, particularly if you're doing, for instance, paper timekeeping, is, say, at the end of the month or at the end of a pay period, have an employee just sign a brief statement saying that the hours that I recorded this pay period or this month are accurate and reflect all of the hours that I've worked. Again, in addition to having time records that appear plausible, that is, it's not 8 to 5 every single day, having that certification from the employee. When you get to me, if you're litigating this, it's a lot easier for us to go to the Department of Labor, to a plaintiff's attorney, and say, look, they're saying now that they were working all these other hours, or that that they weren't being paid for time that they worked. But every 2 weeks or every month, they signed and said that they, the time that they recorded was accurate. So that's something to think about if this is a concern. Let's talk about how to calculate overtime. So assuming that somebody is covered by the FLSA, generally, as I think most of us know and we talk about, overtime is any time worked over 40 hours in a work week. The three kind of pieces that I have bold here on the slide reflect a kind of terms of art. So we're going to talk about each of them. I think it starts with the work week. So a lot of employers might think that you just need to pay overtime for time worked over 80 hours in a pay period. Or if somebody works 60 hours in week 1 of a pay period and 20 hours in week 2, you don't need to pay overtime. That's not right, and one of the reasons is because of the work week. So overtime is calculated based on a work week. A work week is a 7-day period of 24-hour days. So from Sunday at 12:01 a.m. to Saturday at midnight. Every work week is a standalone week. So going back to my little hypothetical about working 60 hours in week 1 and 20 hours in week 2, generally you're going to have to pay a non-exempt employee overtime for 20 hours in that first week. So that's 60 minus 40. And you're going to have to pay them at 1.5 times their regular rate for those 20 hours. Let's go to the regular rate. Regular rate gets a little bit complicated. Essentially, the regular rate is the total pay. The total pay for their total pay for the work week divided by the hours worked. So, if you are getting paid $10 an hour for 60 hours a week, your total pay is $600. And the time and a half for the extra 20 hours is going to be 1.5 times their regular rate. Their regular rate, would be $10 an hour. This gets complicated when you are paying on a salary basis. So we talked about alternatives to paying on an hourly basis. I think it's simple enough. I think most of us understand if you're just paying on an hourly basis, any hours worked over those 40 hours are going to be time and a half, that hourly rate. But if you're paying somebody on a salary basis, those numbers are going to change. And so if their salary, the agreement with them, and again, you're going to have to comply with some suggestions, including having an actual agreement. We recommend a written agreement. If you're paying a salary for all hours worked, that salary, say you pay somebody $500 and they work 50 hours, their regular rate is their salary, which is intended to cover all hours worked, divided by all of the hours they worked. And you get a number, and that number is the regular rate. So in the 50 hours and $500 a week, again, their rate would be $10 an hour. However, if they work 60 hours a week, their regular rate is going to be less than $10 an hour. A couple things to note on this. Number one, if you have a salary that covers all hours worked, you're going to still need to pay the minimum wage. So if somebody works, say, 80 hours, and they're paid $400 a week in salary, they're not getting paid the minimum wage. So if that's the case, you're going to have to gross up their pay to meet the minimum wage. There are also, as I suggested, when you're paying employees on a salary who are not covered by the FLSA, issues in calculating overtime, so whether it's 0.5 or 1.5 times the regular rate. This can get complicated. Honestly, I use spreadsheets that have formulas, so as you can probably tell already, I'm not great at off-the-cuff math, but because they get complicated, this is something that you have to pay close attention to. You might use payroll software that can be helpful for this, but you still need to be careful. So again, talk to the Pro Bono Partnership, talk to your attorney if you have questions about payment for salaried individuals who are covered by the FLSA. Hours worked is the last thing, and so we're going to talk a little bit, I mentioned, about bring your own device policies, and the FLSA requires employers to pay for any employee time in which the employer accepts or permits an employee to work. So what does that mean? it doesn't just mean, as we talked about before, me as a manager saying you were only supposed to work from 8 to 5. If employees are doing work off the clock or work that I haven't directly told them to do, if I'm accepting that work, then, and if that work is benefiting or could benefit the organization, they have to be paid for that. That doesn't mean, again, that you can't or shouldn't discipline employees for not following rules, but it does mean that you have to pay them for work done. So that brings us to bring your own device, and there are all kinds of issues that come up with this, and other issues too that we're not going to have time to get too deep into here, but issues involving, for instance, lunch breaks and travel time, and time spent at work doing both personal and work duties. These are complicated issues, and so again, talk to Pro Bono Partnership or talk to your attorney if you have questions about that. If you have general questions, I can try to answer them. Bring your own device is again kind of a new area of the law, but it brings into question the same things that we've been talking about here. So if you have employees who have work email on their phone, do you have a policy that discusses when they ought to be checking their emails or when they should be responding to emails? Do your employees use their personal phone for work purposes? The probably first way to deal with these issues is to have a policy. Policies are going to be different depending on each organization and how you want to run your organization, but with most employers that we deal with, it's just inevitable that people are going to be performing work on their cell phones, on their personal computers, laptops, tablets, outside of work, or they're going to be tempted to. And so you should have a policy to deal with that. Again, part of dealing with potential issues with employees working outside of work on their cell phones or tablets is to have this regular periodic certification by employees that this record of their hours worked is accurate. And if working outside of regular work times is an issue, you probably want to include something to the effect that the employee agrees and understands that the time they've recorded includes all time worked outside of the regular workday. This also touches on just another general issue. This isn't necessarily a wage hour issue, but there are all kinds of data security and data theft issues that we've been hearing about recently, and there are all kinds of issues with having employees have access to your organization's records on their personal devices. So you're going to want to have in that, bring your own device and security policy, policies about how to keep all of your confidential information safe. That's particularly important for organizations that deal with their clients' records, personal information, medical information. There are a lot of potholes there to try to steer clear of. All right, our time is running short here, but I saved the scary slide for last, and this is what happens if you don't comply with the Fair Labor Standards Act. Businesses, I get to talk about for-profit businesses. It's a little bit scarier, but owners and people who have an ownership interest at a certain level in for-profit enterprises can be held individually liable for violations of the FLSA. Let's talk about what this could mean. If you have not been paying an employee who is found to be covered by the FLSA overtime, those employees can get back wages. They can get back wages for up to 3 years. They can also get liquidated damages, and liquidated damages just means double or triple the amount of back wages that that have not been paid. It starts adding up quickly. If you have a lot of employees and a lot of employees are found to have not been paid according to the FLSA if they're covered, there are civil penalties of over $1,000 a person, so that can add up. And then the issue that a lot of our clients really sticks in their craw is that you're going to have to pay for not only your attorneys, but also the other side's attorneys. Attorneys' fees can rack up quickly. We see settlements in FLSA litigation most of the time, frankly, because of this attorney's fees provision. There are cases where an employee has gotten something like $15,000 in back wages, but the employer has been ordered to pay over $100,000 of attorney's fees. These things get expensive. So it's a complicated area of the law, but it's worth it to think about these issues on the front end. Or if you think that you have these issues now, think about them now. It's better to talk to the pro bono partnership, talk to your attorney, and get your organization in compliance, or make sure that you're following the record-keeping requirements and the overtime and minimum wage requirements now, rather than to have to come to me or another litigator after the Department of Labor comes to you and you have a heart attack because you're not sure if you've been doing this right for all these years. So, all of the employers that I work with are trying to do this right. And like I said earlier, I think that it's a good opportunity, thinking about compliance with the FLSA, to A, make sure you're doing it right, and B, use kind of the silver lining of this to help think about how you manage your employees, and help think about how you talk to your employees about the work that they do and how important it is, and that they should be paid for it, and that any of these requirements, they're legal requirements, but it's also because we want to make sure that our employees are treated fairly and paid for the time that they've worked. So again, thank you for joining us today. Thank you to the Pro Bono Partnership. Yeah, I'd love to answer any questions.
Okay.
Sure.
One person is asking if an organization regularly pays hourly rate to an individual who works on, for example, Thursdays normally. Would they have to pay them for holidays, company holidays that happen to fall on those days, like Thanksgiving, if they're not working on that day?
No, not necessarily. A lot of this has to do with what your company policy is. If the policy says that you pay, there's a potential that that could be some kind of implied contract to pay for those days. But generally, if there is a holiday and an employee generally works on that holiday, if they're not a salaried employee, no, it's just like a day that they're not regularly scheduled to work. There are issues that come up when, for instance, your organization is closed or partially closed due to weather issues. We remember the snowpocalypse here. There are issues with whether you pay employees who typically would have come in, employees who were able to come in but didn't because the organization was closed. Of course, employees who are maybe working from home. So, generally, no, you don't have to pay for holidays that are not worked by employees. Just be careful, because if that employee only works on Thursday, and that's when they're supposed to get their work for the day or for the week done, are they really not working? Were they not working on Wednesday from home? Be careful about that.
Okay, one more question. What about comp time? Can this be used in lieu of overtime if they're salaried, non-exempt?
In private employers, so most nonprofits, comp time cannot be used outside of work weeks. So, if somebody in week 1 works 50 hours a week, you can't then tell them in week 2, go ahead and work 30 hours, and then we're set, no overtime. You still have to pay overtime for that week 1. Some common ways to deal with this are just kind of thinking ahead of time about scheduling. So if somebody works, typically works 8 hours a day, 5 days a week, and on Tuesday they work 15 hours, you can say take off, oh geez, I've done it now with the math, you can say take off 7 hours on Friday. So no, you don't. You can essentially use comp time within a week, within a work week. But really what you're doing is you're just managing that 40-hour per week timeline. So the same rules apply. Individuals who work over 40 hours in a work week still have to be paid overtime for those hours over. But you can say you're not allowed to work on Friday so that we keep your hours at 40. But over 2 separate weeks, for private employers, you can't. There are different rules for public, state, local, city, federal employees using comp time. Something that has come up before, somebody's asked, well, can we do time and a half comp time for hours over 40? No, you can't. You still have to pay overtime. If you're talking about doing this over 2 or more work weeks. Yeah, and it's a common question. So look, be careful if that's a situation that you have agreed with your employees on.
That's all the questions we have.
All right.
Thank you.